want to thank each of you for participating in today's webinar. Drugs Don't Work is very proud to be hosting this event. And as part of our ongoing efforts in New Jersey to be able to provide businesses a drug-free, safe environment for both the employers and the employees. Today's event is the largest event the Partnership for a Drug-Free New Jersey in its 25-year history has ever had in addressing workplace issues. In fact, we have over 700 New Jersey businesses participating today. Now, one of the things we want to mention to you is that all of the programs the partnership offers are free of charge, and we hope that you will take advantage of not only this program, but many of the other programs that are available. Today, we have a very esteemed group of speakers. We have with us today Lauren Marcus and Nancy DeLue, both legal experts in the field of workplace issues. Nancy, in fact, has been a speaker at this event for over 2 decades, and she, along with Lauren, bring a wealth of knowledge, not only about what's happening specifically in New Jersey, but throughout the country. We also have with us today, who's going to be moderating the rest of the meeting, Bert Barron. Bert is a dear friend of the partnership. He is in the Radio Hall of Fame in New Jersey and has really been a great ally in helping us get messages out about the work that we do. So at this point in time, once again, I want to thank each of you for participating. We hope that you will learn quite a bit of information that will be helpful in your business, and also learn about what challenges we have ahead, because there's no question, as New Jersey enters into a new era of legalized use of cannabis and marijuana, that this new law does pose challenges for all of us, and in particular for an employer. So hopefully today we'll be able to help provide some clarity on some of these issues. So right now it's my pleasure to introduce Bert, and he'll take over for the rest of the meeting. Thank you, Bert.
Angelo, thank you. I greatly appreciate that introduction, and it's my honor to serve as your moderator for today. And as a longtime advocate and ambassador for Partnership for Drug-Free New Jersey, I'm honored to be a part of today's event. As you heard Angelo mention, we have many topics to cover for today's webinar: drug testing, measuring impairment, and the status of the Workplace Impairment Recognition Expert, or the WIRE, just to name a few of the topics that we'll cover today. So this webinar will offer employers a better understanding of where we are in New Jersey and how to best handle marijuana use from the workplace perspective. And thankfully, we have 2 really great experts who I will introduce in just a moment. Just a few very quick housekeeping details before we do get started. The slide presentation and a recording of the webinar today will be available and sent to all participants. And many of you submitted questions when you registered. We thank you for that. We'll try to address as many of those questions as possible today. And if you have a question now, you could always send those to us using the chat feature today. So let us meet our expert speakers for today. Nancy N. DeLogue, well known to members of our drug-free workplace program, and she has presented for the partnership for a number of years, as you heard Angelo mention. Nancy is a shareholder of Littler Mendelsohn PC and is a nationally recognized authority on federal and state drug-free workplace and drug testing issues. She has spent much of her career focusing on workplace drug policies and procedures, including programs that are mandated by the Department of Transportation. Also with us today, we're very honored to be joined by Lauren Marcus. Lauren is also a shareholder at Littler Mendelsohn, works out of their Newark, New Jersey office. She represents and advises employers in various aspects of employment law and regularly advises and counsels clients on a wide array of day-to-day concerns, including leaves of absence issues, wage and hour questions, handbooks and policies as well. We are so grateful to have both Nancy and Lauren with us today. And now I'll turn things over to them. Nancy and Lauren, good morning.
Good morning, Bert. Thank you so much for having us. Lauren and I are delighted to be here. We are, we talk to employers every day about issues about impairment in the workplace, policies, procedures. I think it's easy to have a policy, it's easy to have a procedure. It's actually a lot more challenging to implement it correctly. And so when we get a chance to actually interact with other employers, such as I assume are most of you on the webinar today, we're grateful to kind of get a chance to hear feedback and also share with you what our experiences are. That's all we do, by the way. Littler Mendelsohn just does labor and employment law and only represents employers. So we do have a lot of experience here. And Lauren has, of course, based in Newark, has special expertise on everything that's going on in New Jersey today. And as you all know, which is why you're here, it's marijuana all the time in terms of drug issues. Sometimes it seems that way. So I put an agenda up on the screen. This is really not like, we're not going to go through like it's kind of a lesson, but this is what we want to try and cover today, right? We've got marijuana, we've got cannabis in New Jersey. We'll talk about the difference between those two. How does it impact the workplace? What can you expect? What can you require? Can you test for marijuana? Should you test for marijuana? And what about impairment and performance issues? So just to launch right into it, some of this will be familiar to you. All of this kind of happened, on a sort of a slow roll. The law was passed in early 2021 and became effective as to the New Jersey workplace in August 21, right, Lauren?
Yep.
Yeah, so we talk about marijuana, and I'm going to tell you why we talk about marijuana. And again, I'm not going to just read the bullet points here, but we use the term cannabis because, we use the term marijuana because from a sort of like an actual real, like, how does cannabis work? Cannabis is a plant, right? And cannabis products can include both plant materials that get you high or can cause impairment, or plant materials that may be helpful for your health, or plant materials that are, don't actually do a darn thing. And some cannabis products are lawful as a matter of federal law, and most cannabis products are not. So we want to kind of just sort of set the stage. When New Jersey uses the term cannabis, we're talking about marijuana, which is what we consider to be the more problematic, right, for the workplace aspects of marijuana, of cannabis use. And that is the part that gets you high, right? It's the THC. There are two types of THC, Delta 9 THC, and you may have heard in the last year or so more about Delta H THC. Delta, I can't even say that, Delta 8 THC, tetrahydrocannabinoids. See, I can roll the big words off my tongue. So as a matter of federal law, the reason you see cannabis products, if you go outside of New Jersey, right, on the shelves, CBD lotions and maybe gummies or things like that, those don't have a lot of THC in them. If they have less than 1/3%, that means they're lawful as a matter of federal law. Weirdly, I'm not even going to get into this today, Delta 8 THC somehow appears to be lawful under federal law. That seems to have been an oversight on the part of the regulators. And so that actually also can get you high. And we have a lot of companies sort of developing and trying to sell Delta 8, vape cartridges and products like that. Not as strong or slightly different from Delta 9. What we worry about is the Delta 9 THC. And we talk about that. We talk about marijuana because our focus today is on products that might cause an issue in the workplace, and that is those that cause impairment. So hence we talk about, marijuana rather than cannabis. And we're not going to focus on cannabis products that are not psychoactive for our discussion today. Lauren, do you want to talk a little bit about the New Jersey CREMA?
Oh, so this is why we're all here today, right? So this law, which, as Nancy showed you the agenda, we have a lot to discuss with you today, and I will preempt most of it with, I apologize. I know the questions are going to go through the roof. We will try to answer what we can. Unfortunately, for those of you who were, fortunate enough to join us last year for a similar speech, we still have not a lot of answers. So I'm going to go through this, but just so you know, New Jersey likes to just confuse employers and make this all a bit difficult for us. So they enacted the law in February 2021. This was in response to something that was put on the ballot, a constitutional referendum to legalize recreational marijuana in New Jersey. In relevant aspect to us, and so the law created how you could sell it, who could sell it, all sorts of different regulatory schemes. But for today's purposes, the section that applies to employers limits what employers can do and what actions they can take against employees who may use marijuana or marijuana products off duty. So basically, it legalized the recreational use of marijuana by adults over 21 and over. It says that that is now a protected category. This was New York and New Jersey kind of neck and neck were the first states to do this, and they remain having the strongest protections. So the law passed in February of 2021. The employee protections did not become effective until August 19th, 2021. So that's when the New Jersey Cannabis Regulatory Commission, what we call the commission, issued its first regulations. So that is when the employer protections, came to fruition. And what they say is that employers cannot take action against someone based solely on the presence of cannabinoid metabolites in someone's system. So basically, if an employee tests positive, they may have been lawfully using marijuana off duty, and we can't take action against that. And we will, dig more into that as we go forward with today's presentation, but that's really the big crux of what we're dealing with today, is that if someone tests positive for marijuana, you don't know that that actually means they're impaired at work. You can still say you can't come to work impaired, you can't come to work with marijuana, you can't use marijuana at work. But if you use it off duty, if you use it at home, if you use it at night, and you come to work not impaired, that's okay, and that's protected, and we can't take action against you. So that's the big thing we're dealing with in New Jersey.
So Lauren, what about at work marijuana use? Are you seeing that? Is that protected?
No, it is not protected. This is the one thing I will say, and I've said this to Nancy several times. The big thing is you cannot use marijuana at work. That's a no-no. Medicinal, recreational, no matter what, you have a right to say that that cannot come to work. It cannot be used at work. If you see people using it at work, you can take action against them. Nothing has changed. You cannot let people use marijuana at work. Studies show the National Safety Council came out and said, as you see on the screen, 48% of the workers say that they use cannabis products. That does not mean at work. That's just in general.
And doesn't mean marijuana either, right? Like that could be any cannabis product. Yeah.
That is a good point. Yes, the cannabis products, which as Nancy just told us, includes things that are not necessarily unlawful under federal law and do not necessarily get you high. 1 in 3 employees say that they have witnessed marijuana use at work.
And we're hearing a lot of that. We're getting a lot of employers calling and saying people are lighting up in the parking lot. Is there anything we can do about that? And I think that when this law first passed, we thought, well, surely, if marijuana is going to be regulated like alcohol, that people will understand that they're not allowed to, bring it in, pop one open in their car kind of thing at their lunch hour. Maybe a lot more people were using alcohol at lunch than I realized, and we just weren't aware of it. But as, employers who get the call, what can we do? We are seeing a lot of employees and employers just struggle with the idea that they think that now that it's lawful, they can use it wherever, whenever. And so there's a lot of sort of employer consternation about whether you can act and whether you should act. And, without getting into individualized advice, I think Lauren and I would agree. We think it's a bad idea to have employees using marijuana on your premises. So we'll just leave it at that. I know that we're going to go over this, and some of you are well aware of this, right? This is something that's been on has been a law for 18 months now. But I will say, just this morning, and every day I get a call or an email from a client, and they say, oh, we just had an applicant test positive on a pre-hired drug test, and we sent the pre-adverse action notice to say that we're withdrawing the offer. And they wrote back and said, pretty sure that's discrimination in the state of New Jersey now, and you can't do it. Like, are they right? I was like, yeah, the applicant is right. So you need to know these things, and there are still lots of employers out there for whom this is news, particularly if you have multi-state operations and you're in New Jersey and you're one of those employers that has maybe centralized leadership in another state, this might be something that you should be elevating to their attention, because they're still news to everyone. As Lauren said, you're at the vanguard of changes to marijuana law, and you're still, in terms of employee protections, as you'll hear throughout the presentation today, you're sort of the tip of the spear. We're waiting to see where New Jersey goes. So Lauren, gave us a great summary, but what does the law say about marijuana in the workplace? We're gonna kind of break that down and go in a little more of detail. People are asking questions like, what does it mean to be impaired? What does it mean to be high? And we'll try and get into that. Somebody says, what about at-will employment? Does that overrule everything? No, the law overrules. This law overrules any alternative law. And I even have a case that we'll discuss in a couple of minutes that kind of illustrates that. So hopefully we can get you that, that information. So what does the law say about marijuana in the workplace? As a general rule, this is a pull quote almost exactly from the statute. So take a look at it. You are not to be permitted to refuse to hire any person. You can't refuse to hire anyone, and you can't discharge or take adverse action against anyone, employee. And when I say, and I've left the parenthetical in there, so what does it mean to take adverse action? I've had employers who say, well, it is a safety sensitive rule, so we'll just put them in another rule, or we'll pay them less or something. No, you cannot take any action that they might consider, or that would be considered adverse, including to their compensation or the other terms and conditions of their employment, because they do or do not use cannabis products. So that's the bottom line. And then everything else is kind of working around the edges. And Lauren, you've already covered this really well. You can't take any adverse employment action simply because they have tested positive for cannabinoid metabolites. And this is going to get into the weeds a little bit, pun intended, but what is a metabolite and how does that work out? So can we continue to test for marijuana? Yes. Lauren covered this last year, and I tried to punch it up a little bit in terms of the slides. The law doesn't say you can't test. You just can't do anything with the results of the test. So if you've been testing people outside of this law, and you're like, well, we have been testing for marijuana, that's okay, right? You're not going to be in trouble for not amending your drug testing program overnight. Or I've heard from some clients, they're like, my vendor won't take THC off the panel. They say they can't manage that. I don't think that's ideal, right? But you can still test, but you can't do anything with the results. Okay, so back to cannabis versus marijuana and metabolites and impairment. Employer drug tests look for the presence of delta-9 THC, not CBD, not delta-8 CBD, not other cannabis things. The only thing you are testing for is delta-9 THC. You are testing for active cannabis and or their metabolites, depending on the test that you are running, okay? So typically though, a urine drug test is looking for a marijuana metabolite. And the molecules, and I put it like the Webster's dictionary definition, what is a metabolite? These are the molecules that are created when the human body metabolizes marijuana. Once you've already digested it, if you will, not that you've necessarily eaten it, but you are metabolizing it and it is moving out of your system when you are testing urine. Urine is being excreted from the body, right? So it's not just like you inhale or eat your marijuana and it sort of soaks throughout all your body fluids, although that can happen. It gets into the urine by being metabolized. And the law, as we just says you can't take adverse action simply based on marijuana metabolites. Well, what if we had a drug test that didn't test for metabolites? What if we had a drug test that only tested for the active marijuana in someone's system? That may be where sort of the future of marijuana is testing is going, because that's starting to get interest in California and other locations. But right now, if you're doing urine testing, I assure you, you are testing for THC metabolites, and that is what you cannot rely upon in making employment decisions. So yeah, here it is. It's actually not Merriam-Webster's. It was the Medline Plus Medical Encyclopedia. So what is a metabolite? Something produced during metabolism. It may also refer to the product that remains after a drug is broken down. So truly, there's no amount of marijuana metabolite that somehow indicates that someone is impaired, right? It just shows that they used a lot recently, but they've metabolized it out of their system. So that's kind of where we go there. All right, so you're most likely testing for cannabis metabolites, and the laws don't allow you to rely on that. And so here's where, like, you know, what's the value add of the presentation? What can Laura and I tell you about, you know, what are your options? You can try to demonstrate impairment another way, right? And we get a lot of that. And I've seen some questions kind of in the chat box floating by about what, you know, how do I know when someone's impaired? Or you can act when you have other evidence that the individual has violated your drug-free workplace policies, which Lauren goes back to, you're using it in the parking lot. We don't need a test, right?
Exactly. You know, and this is what we always tell everyone. If you have someone dead to rights with an actual violation of company policy and you can take action against them, you don't need the test. You don't need the metabolites. You don't need to be able to prove that they used it. Like, oh, I went out to the parking lot and one of my employees was on lunch break. They got out of the car, and Nancy actually gave me this example. They got out of the car and there was like a billow of smoke behind them. They had something in their hand that they like threw to the ground and stomped out or whatever. And when I went over, it reeked of marijuana. Their eyes were red and bloodshot. Like, they were clearly impaired. They were clearly during working hours. You know, doing a drug test isn't probably going to do a whole lot to change that and to change your impression of what just happened. And they're not allowed to use marijuana on company property or during working hours, as long as you have the proper policies, which we'll get to also. So, you know, one option for employers is really beef up your policies, come up with systems in play, and really try to, you know, take action against employees and maintain a drug-free workplace without relying on the scientific tests that the law is prohibiting action based upon.
Yeah. So that, I mean, and you know, trying to demonstrate impairment another way could be sort of the reasonable suspicion identification. And we're seeing a bunch of questions about that and references to the wire. We're not going to talk about what is a wire, but for those of you who are asking, you know, how do we know when someone is impaired? We don't have, well, we could give you some ideas, but the state of New Jersey has not dictated how that must go forward, right? So that will be interesting. What about safety sensitive jobs? It's a question we get asked an awful lot, right? Unless the job is subject to federal law or regulation, or you would lose a federal contract. I should have said a federal contract, not a contract. So please accept my apologies for not including that modifier there. There are no exceptions for safety sensitive roles.
Yes, and we know, listen, I know the chat is about to blow up with, but what about this? What about this? There are no exceptions. I will say, and I know we were going to touch on this a little bit later as well, the legislature seems to be aware of this problem. There seems to be a lot of, you know, feet stomping, trying to get this to be changed, but it's not really going anywhere yet. But as of right now, like construction industry, there is no exception. You have someone, unless they are, you know, unless you would, and you have to have provable adverse action of like losing a federal contract. Unless you can do that, there's technically no safety exceptions for safety sensitive roles.
I just don't think we can emphasize that enough. So I added the slide, no exceptions, we mean it. This is a decision from January 19th, so less than a month old, from the state of New Jersey's Office of Administrative Law in the matter of Richie Lopez in the city of Jersey City. I can't say it like you can, Lauren, so apologies for my Connecticut accent. I know, right? The original tri-state area. We love to poke one another. The state of New Jersey Office of Administrative Law had this matter between Richie Lopez is a cop in Jersey City, and he admitted that he used marijuana. And they were like, "You can't use marijuana. You're a police officer." And he said, "Yes, I can. The law, marijuana is legal now. I didn't use it at work. I just used it at home on the weekend." And so they brought this action, and Administrative Law Judge Susana Guerrero issued her opinion, and it says, and there is nothing in the CREAM Act to suggest the employment protection provision of the statute, she gave the actual citation, does not apply to law enforcement.
And they
Right?
asked for preemption. They tried arguing that the federal law preempts it, and the judge basically said no. So that's
He
going to
said,
be
I am not persuaded, like 6 times in this decision. I am not persuaded. What she actually said, they said it's preempted by federal law. Federal law says you cannot carry a firearm if you use marijuana or other narcotics. That is federal law. You cannot carry a firearm if you use marijuana, the Schedule I substance. And so, you know, I hate to break it to you, but the cops in New Jersey City have firearms. You know, how can we allow him to continue to carry a firearm if he's going to admit that he's a marijuana user? You know, I thought that was a really bold decision for, you know, ALJ Guerrero to say, like, I'm not persuaded that federal law would preempt here. I thought, well, maybe the federal government will do something. I think the federal government will do something, but I don't think it will be in this case. That's because 2 weeks ago, a judge, or I guess it was a 3-judge panel in the U.S. Court of Appeals for the Fifth Circuit, which sits in Texas, says the part of the I forget the name of the title, but the law that allows people to carry weapons, that says you can't carry weapons if you are a domestic abuser and you have a restraining order against you, is unconstitutional. That is to say, your significant other may have a restraining order, but it is unconstitutional for the government to take away your weapon in that case. That got a lot of attention. 5 days ago, maybe 4 days ago, another judge in Oklahoma said the marijuana laws, the narcotic laws are unconstitutionally prohibit people from carrying weapons. So right now, that federal law is essentially enjoined or under attack. I'm sure there will be appeals and it will continue to apply, and you shouldn't run out and try and purchase a firearm. That's not my area of law or advice, but the idea that the fact that you carry a weapon will bar you from you know, using marijuana is definitely under attack. And in New Jersey right now, the law is that the cops and everybody else, you know, in a safety sensitive role, doctors, firefighters, whoever, they can all use marijuana as a matter of state law. And there is no obvious federal preemption of that rule. So one about safety sensitive rules, there are no exceptions, and you mean it in New Jersey.
take this very, very to the extreme.
Yeah. Yeah, it's a bit surprising. So anyway, so here we are, right? We've got to talk about impairment and performance and some of the questions that people are asking, you know, in the chat. How do we know? I just kind of go over the details again. Again, the state law allows you to do the drug testing, right? The statute actually says that drug testing is okay for marijuana. And what's interesting is New Jersey never really had a statute before regulating workplace drug testing. There was some Supreme Court of New Jersey guidance on how the Supreme Court of New Jersey thought testing should proceed from a privacy perspective, but no limits. Now this law says these following kinds of testing is fine. You know, but you can only act if you can also show the individual is impaired by marijuana, cannabis, right, at work. So why would you test on a pre-hire, random, or scheduled basis as the law permits?
There is no good reason to.
Right? Well, only if you can show that the person is impaired. And the law is a little backwards here. It says, so the drug test must include scientifically reliable, objective testing methods and procedures, such as blood, urine, or saliva, and a physical evaluation in order to determine an employee's state of impairment. So in theory, you're doing a random test, the person pops positive for marijuana, and then you pull them aside and do a physical evaluation to make sure they don't appear to be impaired at work. That could happen. Also, you know, as we discussed before, sometime soon, maybe we'll have drug tests that measure strictly active cannabis in someone's system and not the metabolites, because again, the statute prohibits you from relying on a test that shows the metabolites as evidence of impairment. Okay, so that's where we are. So who gets to conduct this physical evaluation? Lauren, I'm going to let you talk about this because you've been tracking this for a couple of years.
This is probably like the frustration point of the law at this point. So the law came out, it said the physical evaluation has to be conducted by someone who has a necessary certification to opine about the employee's state of impairment or lack thereof. So basically, the law said you're going to have what we call a workplace impairment. Well, so you can use the result of a drug test, assuming that you also use this physical evaluation, and then you're allowed to take adverse action against an employee. You can dismiss them, suspend them, demote them, do what you otherwise would want to do. And so then the question that everyone's asking is, what is this physical evaluation and who's going to do the physical evaluation? So the physical evaluation is going to be done by, oh, look, I jumped ahead a slide, I apologize. So exactly, some people are saying, who's going to do this? A neuroscientist, what are we going to have? What are we going to do? And under the law, they said it's going to be someone called a workplace impairment recognition expert. So as we call them, a wire. And they say that the commission is going to work with the police training commission to come up with standards, training, some sort of certification, and they're going to certify these people to become wires. And then they are going to be qualified to detect and identify if people are impaired at the workplace.
But Lauren, weren't they supposed to do that by August of 2021?
Yes, they were. So when the law was first passed, as you remember from earlier in our presentation, the law became effective in February, but the employment provisions did not become effective until August because they were supposed to become effective when the regulations came out, and the regulations were supposed to include information about what is a wire, how do you get a wire, how do you use a wire, and what can we do? And in kind of typical New Jersey fashion, they punted. They came out with regulations, and the regulation said, we don't yet have any information on a wire. We haven't yet come up with information on a wire. We don't yet know how to become certified as a wire. So for now, we're just still in limbo about this. So now we have a law with these regulations, with these requirements in place, but we still don't know what a wire is, how to become a wire, or what to do. So the commission has suggested employers can make the impairment determination right now without using a wire. So, it's important that that you still have to do this two-step process. You still have to be able to show someone is impaired at work, but now you're doing it without this wire that, I don't know, they still say information's coming soon. So,
I know, it's very frustrating, right? So these, our takeaways kind of here are like, do your best to document impairment. They did issue some guidance that said, carry on as you have before. Like they knew if that was like, I don't know how employers were doing it. But for those of you who have had reasonable suspicion testing, something like that, right? And maybe it's time to update your reasonable suspicion. And we can get into that in a little bit in terms of making sure you have training and things like that. But do your best to document impairment whenever you see it happening. And we have lots of thoughts about that, but essentially, like, right, it's a change in behavior that from what is the norm for the individual. Lauren, you gave me a good example the other day. What's the difference between somebody who comes to work in the morning smelling of marijuana and somebody who doesn't smell like marijuana and comes to work after lunch smelling like marijuana?
Exactly. Everyone keeps asking, what if someone smells like marijuana? Well, the whole point is we're not taking action against someone who could have used marijuana outside of work, right? Like that is now protected. That's like a protected category, just like all our other protected categories. So if someone shows up at work and they smell a bit like marijuana, they could have woken up in the morning and thrown on their shirt from the night before when they were smoking or doing whatever. And listen, maybe not your preferred hygiene habits, but that does not mean that they are impaired. On the flip side, someone comes to work, clean, fresh clothes, doesn't smell, they go outside for 20 minutes and come back inside and just reek of marijuana. I think, that there's a good bet that they were using marijuana during working hours. And now you have reasonable suspicion, or now you have observations. And that would be one of the observations you would note. I will also note the state of New Jersey, when they came out with this updated guidance saying, sorry, we still don't have a wire for you, did provide a sample reasonable suspicion checklist that they suggested. And one of the things I note on it is it does recommend that you have, that you really document any reasonable suspicion, and that you have, more than one person maybe observe these things. So just something to keep in mind. You want it to really be objective criteria, based on observations, and whoever's observing, you want them to document it. You don't want it to be like third-hand information. So
yeah, I tell clients all the time, like, you don't have to be right. You just have to have good reason to want to do that test, right? And act on it. You want to do your best. You should act in good faith. You should, you don't have to be the expert impairment detection. And frankly, very few people are, even trained law enforcement officers call themselves experts on impairment, but you may be the expert on your employee and how they typically behave and how things have changed or how they're acting at a particular time. And so that's the best thing you can do, to handle that in good faith. So, well, should our drug testing policy change then?
I'd recommend it, and I'm pretty sure Nancy does too.
So we're like, although it's okay to conduct pre-hire marijuana tests, you can't act on the results. It's okay to conduct random marijuana tests, but it's pretty difficult to act on the results. Oral fluids and blood tests may aid in demonstrating current impairment. The slide before said, ask your vendor, what are they actually testing for in your samples? And I think we kind of covered this, but we don't think it's a good idea for you to test if you find someone in possession of marijuana or marijuana products at work, because you don't need that test. And frankly, it's just going to confuse the issue. If you have a rule that says don't carry them to work, just enforce it. So.
Absolutely. And some people, just to back up, some people are asking about medical marijuana. The medical marijuana law in New Jersey still exists. It's still in effect. It doesn't have the same impact anymore because now the recreational use is just as protected, but it is another reason to consider eliminating like the pre-hire or random marijuana testing. If you can't take action based on it, it really opens the door for you to get a whole lot of information you might not want about your employees. There's no need to find out about someone's disability or medical use if even their non-medical use is protected. You're just getting more information that later someone can accuse you of discrimination or something. There's just not really a purpose to going down that road.
That's a really good point. Okay, so one of the things that Drugs Don't Work New Jersey wanted us to highlight is just how does the New Jersey law kind of align with the laws of the other jurisdictions. And so recreational marijuana use, as you know, is increasing across the nation. What you see, it's kind of funny, Littler's slide template, right, has two colors of slides, turquoise and marijuana green. So of course I chose marijuana green for this presentation. So the green states here, right, are the states that have either legalized or in some cases decriminalized the use of marijuana. Like there's no marijuana market in Vermont or some of these other jurisdictions, but it's Montana doesn't have one yet, but it's decriminalized. You're not going to get in trouble, Virginia, if you have possession of it, DC. But so this is like, New Jersey's kind of surrounded there or in good company. These are the jurisdictions that protect employee recreational use from an employment perspective, right? So just to go back for a minute, the slides here, these are the states where marijuana is available and you cannot be charged criminally, and where a lot of employees think that that they can't get in trouble at work. But in fact, the only places where it's actually got some protections at work are these. And of these, some of the protections are quite a bit more limited. So by way of example, in Connecticut, right, they've implemented recreational marijuana last July. Off-work marijuana use, it's not a reason for discipline unless the employer has a policy prohibiting it. So if you want to say we're going to keep a rule that says you can't test positive for marijuana in Connecticut, all you have to do is tell your employees that that is your choice. They also exempt any employer in a safety sensitive industry or any employee who holds a safety sensitive role. So Connecticut, really, nearby, but really different from New Jersey's approach. They have this carve out for safety sensitive roles. Nevada's only protection is that you can't do pre-hire marijuana testing unless the role is safety sensitive, because they feel an employer, that's hiring into a safety sensitive role might have reason to like ask about that and follow up on it. Illinois and Maine, it's just, you simply can't refuse to hire somebody because they say they use marijuana or they admit that they have. But if they test positive, you can decide not to hire them. So New York and Rhode Island, like New Jersey, the off-work use of marijuana is protected. There's no adverse action unless the worker uses, possesses, or comes to work impaired, or the individual works in a position that requires testing, such as public safety. A couple of the New York laws say that you've got to be subject to testing if you drive certain vehicles that are not federally regulated CDLs, for example. So right now, New Jersey's protections go way beyond any other state in the union. And there are only 3 that actually prohibit adverse action for safety sensitive worker off work marijuana use. So if you're wondering why there isn't more guidance, if you're wondering how things get proved in court, if you're wondering, what comes next, nobody really knows. Now, I get asked a lot, and Lauren, I know you're tracking this, is New Jersey considering any rule that would make it easier for employers of safety sensitive workers to be a little more rigorous as to potential risks associated with marijuana use? Because I know the National Safety Council, we didn't put all this data up, but it does seem that people who use the number, like in Colorado, the number of people who are like the number of accidents has like maybe doubled that involve drug use since recreational use of marijuana went into effect over a decade ago now. So is New Jersey thinking about doing anything here?
So New Jersey has about 7 distinct laws pending right now, or I shouldn't say pending, that have been introduced to the state legislature that have to do with amending the recreational marijuana law, amending CREMA.
Pending business.
I will say many of them, so in previous years, laws have been introduced and they haven't gained much traction. And they were all about adding safety sensitive exemptions, really paring this down. This year, because we have a new session right now, the ones that have been introduced seem to focus on restrictions for law enforcement officers, people who carry guns, probably a direct result of the case that we previously discussed and similar cases across the state. And there is one bill that's been introduced that says that for safety sensitive roles, you shouldn't need to use a wire. You should be able to really, just make a good faith determination. And that if you have construction workers, you should be, and other safety sensitive positions, you would be allowed to apply to the state for an exemption from the law and basically say, these positions, we should be allowed to just test them and not, and take adverse action based on off-duty use. We shouldn't be restricted this way. They haven't gone anywhere yet. They've been introduced. It's early in the year, so it's not really clear where it's going to go. So we'll be keeping an eye on it. But as of now, everyone seems to be frustrated with the state of the law, but there doesn't seem to be a whole lot of pressure in Trenton to make immediate changes.
So if you're an employer and you want, take the time to look at these bills, I guess, and then probably talk to your local legislator about what you like or what you don't like in what you see, if you think that it's important that something like that happens. We only help you interpret the law after the fact. You've got to make it happen down at the legislature.
Absolutely.
Yeah, so getting kind of close about, and we'll just go through this, what can we require in policy and procedure updates? I think that we've covered most of the high parts, but the high points. It's okay to prohibit the possession and use of marijuana in work and during work time. If you haven't looked at your policy and it uses a lot of legal gobbledygook, maybe consider updating that so people understand. It's okay to discipline people who come to work impaired. It's still okay to drug test for marijuana, but again, not okay to act on the basis of the off-work marijuana use or the basis of a positive test alone, unless that test has some, reasonable suspicion component or, at some point a wire, right? There's no expert opinion and it's unclear what evidence will suffice to establish impairment, but you want to do your best to document that. And if you don't have a policy that has, for example, a checklist or an incident reporting form when you think you have reasonable suspicion, maybe add that to your policies and procedures. There's no exceptions for off-work marijuana use for workers in safety-sensitive roles. And just again, I saw one question in here. We talked about federal regulation. Federal regulations, if you are subject to federal regulation or testing requirements that explicitly prohibit such use, that will overrule the New Jersey protections. But that's right now pretty much people in transportation and nuclear power plants, which I don't even think do even have any of those. So if you have contracts with the federal government, that does not preempt state law, just the fact that you sell to or provide services to the federal government, unless your contract specifically includes a testing component. So go ahead and take a look at that to see whether your policies will hold up in that situation, right?
And that's just to highlight that, that's one of the biggest questions I get is, oh, we have a contract and we're subject to the Drug-Free Act. That's great, but that technically is about keeping a drug-free workplace. That doesn't often actually require testing requirements, and that's going to be very, very different. So you can still have your policies saying no marijuana in the workplace, and you would still be in compliance with that federal contract. It's only if you have a federal government contract that specifically requires that you test and exclude certain people and that you will lose the contract for violating it. That is the only time it's overridden.
Yeah, that's right. And again, we've emphasized that you please act when people bring marijuana products on site or use during the workday. It's permitted, but it's also important because it's like your best tool right now.
Right. And to go with that also, even one step further, we get so many, oh, this person, I'm really sure that they're using marijuana at work, like their performance is bad, or this is happening, or they keep getting into car accidents. Like, check your policies and you can take action against people based on their conduct without it having to be based upon a drug test. So if someone's performance is bad and you think it's because of drug use, you can take action based on their performance. You don't need that drug test. That's just start taking action based on people's actual conduct.
Yeah, I feel like Lauren and I can probably agree on that. And then one of the things we see all the time is when people are like, employers are like, well, we'd like to discipline this person. Their performance has been bad. They've been late 6 out of the last 10 days, but we think it might be medical or caused by drugs. And we're like, why are you speculating? Like, just go with the person. Treat them just as you would anyone else, unless or until there's something else going on. Just treat everyone alike is usually good advice from an employment perspective. Well, I know we want to get to some questions, and I'm sure Bert's been saving them up. I think we just have, oh, we're right there. So yeah, so hopefully, until further guidance, assume you do not need to know why someone is impaired to test, only that they're not conducting themselves as usual, right? And then it is reasonable suspicion of impairment that you're focused on, not necessarily reasonable suspicion that the impairment is caused by drugs or marijuana in particular. So we'll see a lot of reasonable suspicion training updates. I know that there are local organizations that are also helpful to provide that to you. But I want to encourage you to embrace the idea that as you get to manage your people, and you can do that. You don't have to be a neuroscientist. You just need to know that something is off. Bert, I was told that we needed to give you as much time as possible to shoot us questions. Do you have many?
Well, thank you. Yes, several questions here that we will get to, but really, first of all, thank you so much for this very comprehensive presentation and really to show us what's going on and what employers need to be doing. This is really just a really helpful information. So we thank you again so much for sharing it. We'll get to a couple of questions, but I did want to remind our attendees, and again, thank them for signing up for today's event. If you could just take a few moments and be sure to fill out and complete the questions that are in the poll. I believe it's maybe up to 7 or so questions. If you could just take a few moments and complete those as we wind up our event today. Thank you so much for doing so. We do have time for just a couple of questions, and I'll throw them both to both Lauren and Nancy, and you can just determine who will do the answering. But it seems like one of the popular questions that was coming up from our attendees today was the legal differences and maybe legal similarities between the terms impairment and intoxication. Is there commonality between the two? Are they two completely different things? Is it a gray area like some of this feels like? Can you just talk about that a little bit first?
Sure. Lauren, correct me if I'm wrong, but there's not a legal definition within the CREMA as to what is intoxication or impairment. So for example, in Oklahoma, you're deemed impaired if you have a certain amount of marijuana metabolite in your blood, right? We don't have that here. It's just, yeah, so there's no legal definition.
And that's why we have this problem, right? Because there's no definition, so therefore we don't know. If you use a certain test, we don't know. There's not like, oh, this level means you're intoxicated, this level means you're not. They haven't done with marijuana in New Jersey what we've done with alcohol, so there just is no actual definition.
Yeah, and I think, but to answer, I guess, in a focused way, what's the difference between intoxication and impairment is that people can come to work impaired, but they may not be intoxicated. And it gets back to my encouragement on reasonable suspicion testing. And when you have reasonable suspicion, you have reasonable suspicion when someone comes to work apparently impaired. You don't have to believe that they're intoxicated to get the test. You just need to be convinced that they are impaired and that you don't know, right, what is causing it. So the test may be one of several steps that you take to try to, suss out what is going on. So intoxication may be a subset of impairment. People can be impaired because they didn't get enough sleep. People can be impaired because they're having cognitive decline. People can be impaired for lots of different reasons, but intoxication may be a subset of that. So I don't know if that answers the question in terms of like, what do we do with this information? But I do think you have greater freedom to act because you're concerned, right? And you have some objective evidence of impairment without having to become an expert on whether that impairment is in fact caused by drugs or alcohol, or specifically like, is it marijuana or is it some other drug? I mean, I don't know how most anyone would know that. So go with impairment as a trigger to take further steps in your investigation.
Terrific. And the questions, by the way, which are all excellent, they range from the very broad to almost the granular type of what if this and what if that, which is my favorite type of question to ask. So we'll get to a bunch of those. How about for organizations that accept federal funding, or maybe someone who has an employment position where they work for the government in some sort of capacity? What do they need to know about what's going on?
They need to check their contract. Getting the funding is not enough to necessarily mean that you are not bound by this law. I saw some questions about Medicare recipients, Medicaid recipients. You likely have contracts and regulations, and it really depends. If you can, the statute uses language of a provable adverse action. So honestly, it's just go back to your documents, go back to whatever you have with the government, and you have to look at it. It's really going to be fact specific.
Yeah, and I'll say, I don't see too many federal contracts that include testing as a requirement. They may include, promoting a drug-free workplace or taking action if someone comes to work impaired, but that's pretty different. I sometimes see drug testing in DOD, requirements, but there's a lot of federal rules and contracts out there, and they are not as specific as you might like.
Excellent. How about for off-duty use? And this was a popular question as well. We have so many licensed professionals here in the state of New Jersey, everything from accountants to therapists and things like that. Any concerns in terms of off-duty use for those who hold a professional state license? Should there be concerns with someone who holds a New Jersey state license?
So yes, if they're impaired, but no as a general rule, because I think as with the police officers, there are very few, if any, state licensing benefits that can now be denied to someone who uses away from work. Now, there may be some limits on being dependent, right? So if you, and this is like a typical response, I don't know that this is exactly the New Jersey response, but let's say you're a physician or a nurse. The rules generally are that you must report to the state if you believe that someone is dependent upon a narcotic or a prohibited substance, which is really different from saying, oh, I happen to know, Nurse Joy uses marijuana at night kind of thing. But that is, again, something that if you are in that industry, I would encourage you to go and check those regulations that govern the people who are in there so that you know the scope of what you should be looking out for and what you should be reporting. But again, there's no per se, look, guys, cops in New Jersey can use marijuana. What more do you want to know?
Exactly. And honestly, I would just say, and I know it seems a bit like semantics, but, you know, from a practical standpoint, like, don't put the cart before the horse. So, you know, even in the case of the police officers, like, you know, if the argument is, but they shouldn't be allowed to have their gun, blah, 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 and then they couldn't be a police officer. Well, I guess let's see if their gun gets taken away. And once it does, you can fire them because they can't actually do their job. So maybe, you know, there's no exception for you to take action, but, you know, look up the regulations, look up the requirements for certain licenses. And if someone loses their license and then is unable to perform their job, then I guess we have a different conversation.
Yeah. Agree.
Okay, we'll go from one of the broad questions to one of the really very narrow ones here, which is really an excellent question. As a patient who is under the care of a doctor or a dentist or someone who is receiving medical treatment, can a patient, do they have the right to question their doctor if the doctor has been using, or do they have the right to say, have you been using in the last several hours? It could be even someone who's facing a surgery. It could be an early morning in one of our great New Jersey hospitals. As a patient, do I have the ability to ask that question? And is the person providing me with medical care, are they obligated to address the question?
So it's the second question is the good one. I think you can always ask. I don't think there's any obligation for them to answer truthfully. We get a lot of that with like, are you vaccinated too, by the way, Bert? So I think you can ask. I don't know anything that requires them to give you an answer.
Okay, how about for those who are commercial drivers and people who drive for a living? Sometimes they're employed by a large corporation. Some of these are mom and pop businesses that do their own driving, owner operators and things. Impact that these laws and these rules have on them?
Well, it's a great question, and I'll jump on this one because I do a lot with transportation. So if you drive for a living, you can use all the marijuana you want, unless you drive a commercial vehicle that is regulated under federal law, right? So if, let's say I'm delivering packages in my own vehicle in and around rural New Jersey on behalf of like a big vendor or something, there's nothing to prevent me from using marijuana. If, however, I'm driving a vehicle that either requires a commercial driver's license or, and this is a big gray area right now that a lot of people don't understand, if I'm driving a commercial motor vehicle that's subject to DOT regulation and requires me to have a medical card, the medical card says you can't get a medical card if you use a narcotic or any other potentially impairing prescribed medication. So if you need a medical card, you're not going to get a medical card if they find out you use marijuana. So commercial drivers may be medically disqualified or be disqualified if they have a CDL. So very narrow for drivers, maybe train engineers, some pilots, things like that. But in general, if you're just driving your personal vehicle around the state, making small deliveries or carrying tools and going to different facilities to work on them, no exceptions, and don't use it during the workday. You can still be arrested and charged with driving under the influence as well.
Yeah. Terrific. We did talk a lot about the pre-employment testing laws, and I'm glad you covered a lot of that today. We do know that the legal use is for those 21 and over here in New Jersey, but how about the pre-employment testing laws? Are they applicable to those who are under 21? We know that the working age, I worked in New Jersey when I was 16 with my working papers and my first part-time job and whatnot. Do these laws, do they apply to those under 21?
Well, so I would say since you're allowed to do the pre-employment testing for everyone, but you can't take action. But yes, it's for people who lawfully use off-duty marijuana. So if the law is just for, since the law is just for 21 and over, I would say people under 21, you can still take action. It's not the lawful use, but you'd still have to be mindful of medical marijuana, that they may have a medical marijuana card and follow, the Compassionate Use Act and, the applicable New Jersey laws with regard to that.
Yep.
Okay. I think we're going to see a fair amount of employers who are really going to take a pretty firm and a pretty strong stand against this, and talk about an employer who would even like to go so far as to perhaps deny the ability to use, whether on duty or off duty, someone who has a prescription and they are prescribed medical marijuana. Can an employer say, well, if you're using that, I don't want you working for me at all. Can an employer do anything in terms of a legally prescribed cannabis?
Absolutely, and we'd love to defend you in court, but it's going to be expensive.
Yeah. Although I did see
I don't think it's a good idea.
No. But I did see a question before about the medical marijuana at work. And I want to clarify, no one is allowed to use marijuana at work. I don't care if it's medical, I don't care if it's recreational. You are allowed to prohibit use at work for everyone.
Terrific. Okay. Another really great question that came across. How about for those who are staffers or perhaps work at the various substance treatment centers that we have here across our state, where there's constant exposure and you're trying to help people deal with addiction issues and whatnot? Any concerns that maybe staffers who work at these substance treatment centers should be aware of?
I think what were you saying, Nancy?
It's a tough one.
Yeah. I mean, there's not technically an exception.
I think it's like alcohol. It's like, alcoholics, they may be surrounded by alcohol, and it's going to be, it's actually for people who do become dependent or seeking treatment. One of the challenges, if it's alcohol instead of, heroin, for example, is that alcohol is everywhere, right? And that may be true for people who become dependent on cannabis and seek help now. It's going to be an extra component of how to deal with it.
Terrific. One final question, and then we'll get to our concluding remarks. And the questions have all been terrific, by the way. Is there really a definition of off work hours? I mean, someone who is self-employed or maybe works for a small business. We've got so many great small and mom and pop businesses here in the state of New Jersey. Is there a real definition for off work hours? I know what I do for a living. I feel like I'm always working. So I don't know if that exists, if there is a quote unquote off work hours that are legally defined.
I would just say, as an employment attorney, that question makes me sweat, because there are wage and hour laws about when you have to pay people, and you should know when people are on duty and when they're off duty. But that, you as the employer should set the rules and expectations, right? You're either working and you're getting paid for it, or perhaps you're on call. And New York, actually, for their recreational marijuana law, has some guidance about on call, which doesn't apply generally, but you might want to take a look at that for when somebody's on call, or talk to your employment attorney. But pretty much, we would encourage you to delineate when exactly the individual is on work hours and not work hours. And if you have people who are not scheduled to work, they're not working, but they might get a phone call, right, to come in after hours, I would create something that you might already have with alcohol, suggesting you should let us know, right, if you may be impaired. If we seek to call you in for an emergency and you've had a couple glasses of wine or shots of tequila, we'd like to know that, right? And we can reschedule. You can encourage people, let you know when they may be impaired because they've used cannabis.
Understood. All right. Well, we're a couple minutes past 12 o'clock. We understand that with some of our attendees might be getting ready to leave and go back to work and do what they need to do. So we are going to bring things to an end today. Nancy and Lauren, we did want to give both of you a minute just to offer your final thoughts on this very, it seems like an ever-changing subject. So we thank you so much. And just some final thoughts as we conclude. And Lauren, we'll open up the floor to you first.
Oh, I just wanted to, first of all, Bert, thank you. I love hearing your voice. That's why you're here. That's great. But thank everyone for coming. And, as we know, this is still there's a lot of questions surrounding this. This is a really confusing law. We encourage you to, update policies, get help in, maintaining a drug-free workplace policy, review testing policies, and do what you can to help, protect your employees and keep, in compliance with this law while still meeting your obligations, your work needs, and making sure, you're preventing drug use in the workplace.
Terrific. Well, Lauren, thank you so much. And Nancy, we'll give you the final word for today.
Well, thank you. I'm honored, and I'm always glad to come in and talk to the Drugs Don't Work New Jersey folks. It's been a great relationship over the years. I'll kind of pile on with what Lauren said. It's important for you to educate yourself so you understand how the rules are changing, and you don't feel helpless when problems do crop up. You understand what your options are. I will encourage you to further Update your policies and communicate to your employees, because if you're confused, think how much more your employees may be confused. And you may have employees who believe that they are fully entitled to use marijuana on their lunch hour, and they've been great employees of yours, and you don't really want to discipline them. So let them know what you expect, so that you kind of, build that employee relations experience so that they understand what the rules really and truly are and have that dialogue. And, I guess the last thing I'll say is, this is, you're the tip of the spear. New Jersey's way out in front of other states on this. So if maybe it'll work out great, but for things that aren't working out, I do encourage you to go to your legislature and tell them what's working, what's not working from an employer perspective, so that they can continue to kind of be out front in having the best, marijuana policies. You you're out ahead. Let's stay out ahead. Let's keep it fresh and working.
Well, terrific. Well, Lauren and Nancy, thank you very much for being here with us today. We really thank you for that and appreciate that you could give us this presentation today. And we know that these are very challenging times here in our state for employers when it comes to handling marijuana. But I think the presentation that you gave us today really provides employers in our state with a very good sense of where things are and what steps we can take, they can take to maintain a healthy, a safe, and most importantly, a drug-free workplace. So we thank you so much for that. If any of our attendees did send a question in that you didn't feel was answered adequately or didn't get a chance to address, you can send an email to bill@drugfreenj.org. Again, bill@drugfreenj.org. And you could also use the same email address if you'd like to receive a certificate of participation for today for attending the webinar. And you can follow up with Bill Lillis at that email address there again. You will be receiving an email from him that has the recording of the webinar, and also copies of the slides will be made available to all of our attendees as well. The Partnership for Drug-Free New Jersey will continue to monitor any new developments on this important issue and will certainly keep its members fully up to date. So we thank you for attending today's webinar. I'm Burt Barron. It has been my honor today to serve as your moderator. So thank you to our speakers and our attendees. Thank you very much.
Thank you very much.